Hi, folks. Welcome to the video on farm housing rules and regulations. This is hosted by the Cultivemos Legal Cohort. You can find our logos above and throughout the presentation, and I'll tell you each of us more at the end. For now, I'm Rachel Armstrong. I'm the Director of Farm Commons, and I am writing and delivering this video for you. A little bit more about Farm Commons. We're a nonprofit 501c3 organization, and our mission is to empower agricultural communities to address their own legal vulnerabilities within an ecosystem of support. What that looks like is stuff just like this, educational videos. We also produce a lot of guides, run workshops, plan webinars. We have a podcast, and we answer individual questions from folks over our Q&A platform. We also very much believe that the best solutions come by and for farmers. And so we do leadership development in agricultural communities to help elevate folks' ability to take leadership on these issues. We're a membership organization. I can tell you more about that at the end. In this video, we are talking about several broad areas of regulation that come with on-farm housing. First, we have land use regulations that can control when we offer housing. Second, we address safety regulations that control the condition of the housing that is provided. Third, we'll explore wage evaluation issues. So where housing is being accounted for as part of a person's wage, we have to be pretty careful about how the value of the housing is established. This is not a comprehensive analysis of all the laws that pertain to on-farm housing by any means. OSHA regulations, those affecting migrant and seasonal workers, H-2A visa workers, and more can come with additional rules. A comprehensive course, even for domestic workers, would take, let's say, days, maybe a week to get through. But this information will give you enough information to know where you might have an issue and how to move forward in researching more for your own situation. This video does speak directly to farm owners, as they are the person who generally has the most control over farm housing and compliance with the regulations that affect it. However, it is still useful for farm owners who aren't owners to understand if an operation might be in compliance. Either situation, bear in mind that this presentation is educational in nature. We are here to help you explore what the rules are and what compliance looks like. We are not telling anyone what to do in their specific situation. We don't know your specific situation, so we're not telling you what to do. We appreciate you keeping that close in mind as you watch today's video. Let's start with land use regulations. Okay, this is one of the first things to consider when pondering on-farm housing. Is it going to be allowed? Here are 3 different ways that on-farm housing might not be allowed. First, the local zoning code could be an issue. Zoning codes often set restrictions on the number of buildings on a specific parcel that can make it hard to build new worker housing. Even if the code allows for many farm buildings, it might restrict the number of residential units or houses on a parcel. There might even be restrictions on the number of unrelated people that can occupy a house that is allowed on the property. Restrictions getting right down to the number of unrelated people in a home are more common in residential districts rather than agricultural. But with many urban and suburban farms in our midst, the issue is certainly a relevant one. So what does the person need to do? Well, to move forward, we got to research the zoning code for the property in question. There are municipal or county ordinances or other levels of local government generally, and they are housed with that entity's land use regulations, generally speaking. It's often called the zoning office, but it can go by another name like land use and planning or something like that. To actually look up the rules that affect your specific parcel usually happens in 2 steps. First, you're going to figure out which zone your property falls into on the zoning map. Then you look up what is allowed or disallowed within that zone. These zones often go by the name R1 for residential or A2 for agricultural. So you'd look up what is allowed or disallowed in R1 or A2. You can also call the office, give them your address, and ask for help figuring out what is allowed in your area. If you prefer, consider the public library and asking a reference librarian for help finding the code and understanding how it applies to your parcel. So zoning codes are created and enforced through democratic processes and public input, but we also can have entirely private restrictions that affect our ability to have farm worker housing. These restrictions usually affect just one property or parcel, and they can affect each one differently that has one. So these are restrictions that the property owner voluntarily agreed to at one time. Although the land may have changed owners since that time, the restrictions can still control the property. So a property may have a deed restriction placed on it that limits the number of residential units or unrelated persons that can occupy that home. Conservation easements can also restrict the number of homes on a parcel and the relationships of who can occupy the home. How do you figure out if one of these exists for your property? It often requires a trip down to the land records office, often at the county level, but could also be municipal or otherwise. It's usually literally an office that has drawers that stores all the deeds and land records for the property within that county. In order to look up your parcel, you usually need to know your parcel number, often contained on tax records and things like that. However, if you have the address, office staff may be able to look that up for you. From there, you can ask to see the deed for the property and anything relevant to the deed that is also on file. If you want copies of that, offices usually have some sort of photocopying fee or other fees for accessing the information. Some offices also have a self-service station where you can look up and print the information on your own. Once you locate it, well, then it does become your job to read these materials and try to figure out what they mean. And that's what a deed restriction looks like, just a document with words on it that you look up to figure out what does this thing say? What does it mean? Of course, you can also take the documents to an attorney for a professional analysis of what they require or prohibit. Third on our list of potential issues or land use regulations that might affect you are rental permits. We might have a property that is zoned to allow farm worker housing. It might have no deed restrictions, no conservation easements that would limit us. So can we go ahead? Well, we also need to check if a rental permit is required in our location. Many municipalities require rental permits to be applied for and received before any home can be rented to tenants, including tenants that you might host in the home where you also live. These permits might be limited for a total number that the community will issue. So it is possible that there will be no permits available at the time when you need one. Rental permits also might come with additional requirements for the condition of the house, for example, like fire escape routes, bedroom sizes, rules about the number of parking spaces you have to provide, and so forth. So you definitely want to take a look at if a permit is available, and if so, what does it require? To move forward with this, figure out if your local unit of government, municipality, county, town, township, whatever, if they regulate rental housing with a permit process. Ask them or search online for more information about who needs a permit and how to secure one. Let's move on to health and safety regulations. So we're moving away from land use and into how do we keep people safe that are staying on our property. Farmers need to be aware that by providing housing to their workers, they may subject their farms to an inspection under the Federal Occupational Safety and Health Act, which we all commonly know as OSHA. Although OSHA is generally not enforceable against smaller farms, that exception does not apply when housing is provided. And this is because the rules require that the rules say that a farm with a temporary labor camp is subject to enforcement. The temporary labor camp basically is any housing that's provided to a temporary worker as a condition of employment. And it can be a condition of employment if, for all intents and purposes, the individual has no other choice but to live in the housing on the farm because there isn't other housing available, or because they're required to stay on the farm because of the job itself. So, for example, this might occur if the farm is in a heavily rural area and there really aren't other houses around. All right. So, if the worker is offered the job on the condition that they accept it as part of their wages, then again, OSHA would be enforceable. The U.S. Department of Labor oversees OSHA compliance in most states. Farmers can contact the federal OSHA offices in their region for more information and details. However, if you are in Maryland and Vermont, a state agency and not federal OSHA, over the Federal Department of Labor oversees OSHA compliance in those states. So Maryland and Vermont, contact your state's OSHA office for more information. Many OSHA offices will also provide on-site consultations. So check that out if this relates to you. Now, if you're curious about what OSHA requires, let's take a closer look. Here's a sampler. You're going to have to ask yourself several questions and make sure that you're satisfying these, and this is going to help you pass an OSHA inspection. Does each room used for sleeping have at least 50 square feet of floor space for each occupant? Does the house where workers cook, live, and sleep have a minimum floor space of 100 square feet per person and have at least a 7-foot ceiling? Are sanitary facilities for storing and preparing food provided in each unit, like cupboards, shelves, working refrigerator? Are the heating, cooking, and water heating equipment installed in compliance with state and local ordinances and regulations? So, for example, the hot water heater needs to be installed according to the code. Of course, we're going to have heating if the housing is being used during cold weather. We need to have working stove and facilities for cooking and preparing food. All right, we're also looking for things like a light fixture and those sorts of good stuff. So nothing too surprising, but it certainly is a checklist that you're going to have to go through to ensure that you are able to pass an OSHA inspection. Another thing that might apply to you is the Migrant and Seasonal Worker Protection Acts, both the federal and state corollaries. If your workers are considered migrant or seasonal, then they have additional rules that can apply to the housing that you are offering. Now, let's take a closer look at what migrant and seasonal worker means. So this usually means someone who comes in from out of state for farm work. So in this way, it can apply to, say, a college student who takes a summer job working at a local farm, so long as they're crossing a state line in order to get to that job. So if they're coming from out of state, these laws may apply. All right, so what do these laws require? Well, the property, particularly the housing, is going to need to go through a pre-occupancy inspection and to get certified. The certification is often done by the United States Department of Labor, but the states may conduct the inspections too, and because they may have their own version of this law. Of course, to get the certification, you got to pass these rules, similar to the checklist that we discussed for OSHA. But also for this law, the terms and conditions around the housing have to be provided in writing and in advance to our worker. So these terms and conditions have to include obvious things like what are you charging for it, but also things that you might not be thinking of top of mind. Like you have to explain any rules that are related to who can visit or who can stay at the house with the worker. Okay, so we've covered whether a farm is allowed to have housing at all. Then we address some health and safety rules that need to be addressed. And assuming we've covered those hurdles, let's now talk about valuation. Most farmers who offer housing value it in some way. For example, they may count the housing provided as part of the wages. or they may charge workers for the housing provided and deduct it from wages. No matter how we structure it, this is a regulated area, and we're going to explain some of the issues that come into play. But before we get there, please note that this does not apply to H-2A visa workers. Different set of rules when you're talking visas. Okay, so with that on the table, I also want you to know the valuation rules are complex. So, hold on. This does get a little bit complicated. To move forward, we've got to ask ourselves a series of questions, which happens a lot in farm employment law, honestly. We're asking questions so that we can ask more questions. First question we're going to ask, is your farm required to pay minimum wage? If the answer is yes, we have to ask a second question. Are you using the value of this housing to meet the obligation to pay minimum wage? If the answer is yes, then you need to follow a stricter set of rules for when you're paying these non-cash wages, this housing. Now, if you answered no, because you are not required to pay the minimum wage, or because you are required to pay at least the minimum wage, but you're doing that and you're providing it in cash, say US dollars, then in that case, these supplemental wages, this housing that you're providing as part of that payment, then you have more flexibility in how you value that housing. Third case, you might be in a position where you have no idea if you are required to pay your employees at least the minimum wage, or might not know exactly what your state's minimum wage is. We totally understand. That happens a lot. In that case, make sure you take a look at the Selected Essentials in Farm Employment Law series at our website. We've got one for each state, and it will help you. It'll tell you when do farms have to pay the minimum wage in your state, and when they do, what is that minimum wage. But let's talk through an example to figure out what this, how we're going to do this evaluation. Let's say we have farmers Jack and Jill. They live in a state where the minimum wage is $7.25 per hour, and let's say they are both required to pay at least that. Jill, for her situation, she pays $8 an hour to her farm workers in cash, meaning just dollars. Doesn't actually mean she hands them bills. It could be a check. So she pays $8 an hour to her worker, but she also provides a beef share and unlimited access to farm-grown produce. She values that meat and produce at about $400 per month. Same case if we were to just say she provides a room in her home that she thinks is worth about $500 or $400 a month. Let's say Jack, on the other hand, pays a stipend to his farm workers worth about $5 an hour. Once you do the math, in terms of all the hours this individual works and what he gets paid per month. But Jack also provides housing and some meals like breakfast and lunch. And he values that at about $1,000 per month. In this case, comparing these two scenarios, Jack is going to need to follow more rules than Jill because his cash wages, $5 an hour, do not equal at least the minimum wage of $7.25 an hour. Okay, so knowing that Jack has to follow more detailed rules, what are they? And they affect that $1,000 valuation. Is Jack doing it right? Can he really say that that's worth $1,000 a month? Let's see. All right, so in this case, here are 4 basic rules that Jack is going to need to follow. First, he's got to make sure he is only using certain types of resources in place of wages. And these are lodging, meals, and transportation. So your housing is going to fit under that lodging. The meals, also if this is like breakfast and lunch, that's good. But do note that groceries are not included on this list. Second, for using these cash equivalents, the lodging, meals, and transportation, they must primarily benefit the employee. Third, if you're offering housing and transportation In place of cash wages, they can't be a condition of employment. So that means that you can't require that they accept the lodging and the meals. If they don't want lodging and meals, they should be able to have its actual cash value in cash instead. Last one, you got to make sure you're using the in-kind, the federal rules for the reasonable cost of the in-kind items. So let's dig in a little bit closer to that specifically. That last fourth one. What is the reasonable value of the in-kind wages? The federal rules set out a very specific method for determining the value of in-kind payments when they're being applied to meet minimum wage obligations. And here it is. Farmers can deduct for the lesser of either the fair market value or the actual cost to the farmer for providing it. Let's get right to an example because it's hard to, it's so much easier to explain these things with an example. Let's say Farmer Sally has a mobile home on her property. She owns it outright. She wants to let one of her workers stay there in exchange for work. So in other words, she's going to offer housing in lieu of some cash wages to this individual. So how much can she deduct from the wages for the value of this housing? She's going to have to go through a two-part assessment. The first step is she needs to determine the fair market value. So we ask ourselves the question, what do mobile homes in Sally's area rent for? If she's in a rural area, it might not be very much. But if she's near a big city or even a bustling small town, this could be a lot more than that. But let's say Sally does some research and she thinks the going rate for a similar mobile home in her area is $400 a month. The next step is she's going to have to determine what it actually costs her to have the mobile home. At the beginning, we said that Sally she owned this outright. It's already paid off. Well, there we know she doesn't have costs for the mobile home itself. Let's say that Sally is only paying utilities for the mobile home. And so the electricity and the heat and all that good stuff runs her about $75 a month. Well, $75 a month is less than the $400 a month. So therefore, $75 a month for the lodging is all that Sally can deduct from the minimum wage that she owes her worker. So this example is quick and easy for the sake of the video. But in reality, Sally should work with an accountant to lay out her actual costs and document how her and her accountant arrived at that calculation. Here's the point. The point of these federal rules is that a farmer or rancher cannot profit from offering in-kind payments as wages. You can't profit from offering housing as wages. If Sally deducted more than it cost her to provide the housing, she would profit. So if you want to provide housing as a way to meet minimum wage obligations, you've got to do some research on things like the price of rent in your area at the going rate. And you have to be honest about what that lodging actually costs you. You got to keep records to support the value that you are accounting for it so that you could get through a tax audit or a wage claim if one arises. All right. So again, the full disclosure, these are simplified examples that I'm offering you to illustrate a point. Farmers who want to incorporate housing into their compensation plan are going to need to follow detailed and precise legal language. We have more details in our guide, Farmer's Guide to In-Kind Wages, in the Farm Commons library. And again, even then, you may still need to work with an accountant to help you meet these obligations. But let's make a big transition. Let's talk about the case where you don't have a minimum wage obligation. You're not required to provide the minimum wage. Well, you got more flexibility here. Your in-kind wages, and again, when I say in-kind wages, I mean the housing, meals, things that you're providing as part of wages. You're not, if you're not doing that to help meet a minimum wage obligation, you are not limited to housing, meals, and transportation. You could provide other things like groceries. You don't have to meet the rule that it be for the workers' benefit and not a condition of employment. And you don't have to follow the federal government's strict valuation rules. You do still need to keep payment records and fulfill the tax obligations. All right. And keep in mind that state rules may still apply. The states do have, many of them do have specific rules about when and how you can provide wages in the form of housing. The Farmer's Guide to In-Kind Wages goes through that in more detail, including the northeastern states and their specifics. Okay, so now you know you're going to have more flexibility when you're not using in-kind wages to meet a minimum wage obligation. But not total freedom. You still have payroll responsibilities, like we alluded to. You're going to have to itemize wages on pay stubs. So if you're offering housing, you're going to need to detail that on the pay stub, what the value of it is. You know, when it's on the pay stub, then you're also going to have to pay payroll taxes on its value. So again, you're reporting to the IRS the full value of what you're providing to the worker, and then you're owing payroll tax on it. And you know how it goes. The IRS needs that remitted as cash. They don't accept zucchini or ground beef or even a night in your guest house for your tax obligation. So that is all the good stuff on offering housing to farm workers and the many rules and regulations that apply. If you are intrigued and want to know more about the farm's legal obligations, consider our workshop, Discovering Resilience. You'll learn the 10 legal best practices of a resilient farm and create a customized action plan. We've got work at your own pace or learn with a cohort of peer options. We also have way more on farm employment law, including our advanced farm employment law course, which is available online. It has about 9 lessons. It's very thorough, a terrific resource, and it's self-paced, so you can take it on your own time. Useful whether you're a farmer, an advocate, or a farm worker. These things are available at our website under our membership program. Membership is highly affordable depending on what type of entity you are, and scholarships may be available. Contact us or check the video description for more information. On behalf of the whole Cultivemos Legal Cohort, we thank you again for watching this video. We are Jackie Schweitzer, Whitney Shields, Francesca Gallo, Sheila Marshman, and myself, Rachel Armstrong. Thank you again.